So 50th anniversary of the Rehabilitation Act.
Yes, that was yesterday.
Right. So explain what it is, because it's a big deal.
So I teach a disability rights law course here at the school. This is my first semester teaching that. I've taught government lawyering, other courses. We've been focused on the Rehabilitation Act. The Rehabilitation Act was really the first major piece of civil rights legislation in the disability area. It came after Title VII. It came after the Civil Rights Act of 1964, after Executive Order 11246, which both came during the civil rights movement. And disability had been left out. And so there was a real push among disability advocates. Hey, what about us? Why aren't we included? Why can you have discrimination based on disability? And some of the Supreme Court precedents from that time allowed disability to be treated differently than race and gender, for example, where you have higher levels of scrutiny for government action. Strict scrutiny for race, intermediate scrutiny for gender. For disability, it was only rational basis scrutiny. So there was this idea that, hey, we need to put in statutes, in the law, protections for people with disabilities. The Rehab Act is not as broad as the Americans with Disabilities Act, which is more well-known. But the Rehabilitation Act applies to any companies, if they meet certain jurisdictional requirements, that receive federal funds, that are a federal contractor, or the federal government itself. And it requires those entities to not discriminate based on disability and to grant accommodations, reasonable accommodations.
College affirmative action. Okay. I don't know if everyone's up on this, but there was a ruling around affirmative action for college entrance. Okay. Everyone panicked in employment because they were like, what does this mean? And then we started seeing a massive retreat on people's commitment to DEI initiatives. So that's diversity, equity, inclusion. There's also belonging. So you'll hear DEIB. But all of this caused a panic. So I'm going to ask you to take it first, and then we're going to get it correct.
Well, from the EEOC side, it's pretty easy. Race-conscious decisions in employment have been illegal since 1964. So just like you can't fire somebody because of their race, which everyone knows, you also can't hire somebody because of their race, religion, national origin, gender, any of the protected characteristics. So, certainly there's been in the academic area where this case has significant impact. There's very, very rare circumstances under our laws where you can make a race-conscious hiring decision. It's a voluntary affirmative action program. It's very, very hard to prove. It's very hard. It's not used that often. You have to show that historically at your company that there has been a racial disparity, and you are going to correct that. And very few companies actually engage in that are not federal contractors. So from our perspective at the EEOC, it doesn't really impact that much because some of the issues that were going on in the academic world were already prohibited in employment. But I think it's a little different in the affirmative action.
Yes, this is where there's a big difference.
From the OFCCP perspective, and again, I'm speaking as the former director, so I don't speak for the agency anymore, but I follow them. And I'm pretty aware of a lot of what's going on just from my past experience. So, OFCCP takes the same view that if you make an employment decision, like a hire, fire, raise, that can't be based on race. Now, OFCCP will say that you should be race aware in the sense that, you do have this affirmative action obligation. You're collecting this data as to race and gender, for example, and you are supposed to do pay equity audits and hiring audits to make sure you're not discriminating, which is illegal. So if you can show that you're discriminating in a particular, not that you want to, but if you happen to see that, you can take action to address that but basically focusing on those who have been discriminated against. So then you're not really basing it on race, you're basing it on the group of people who have been discriminated against. So women get paid less than men in a particular job group. You demonstrate that to 2 standard deviations. You can make pay adjustments to those women to address that pay gap. And that's not viewed as a race conscious or a gender conscious decision. Now, sort of the elephant in the room would be the affirmative action component. Now, one thing you need to know is that affirmative action in employment is not the same as affirmative action in higher education admissions. And in fact, there's a good argument that maybe higher education should take a look at affirmative action in employment as to how they should do what they're doing. What affirmative action in employment looks at is you look at, and this is if you're under OFCCP's jurisdiction, you're a federal contractor, you have an affirmative action obligation, you assess your workforce based on race and gender. You look at the representation in a particular EO1 job category, for example, like technicians or professionals or higher level executives. And you compare that to the availability data for your metropolitan area, or sometimes a broader area if you recruit more broadly. So let's say, for example, with software programmers, let's say that you look at the availability data in your area and it's 70% male, 30% female. And let's say you look at your software programmers, you're a tech company, and it's 80% male, 20% female. Well, then you're underutilized, it's called, or you're underrepresented as to 10% as to women. Now, does that mean you go out and you hire the next 100 people? You're going to only hire women? No, that's considered employment discrimination. But what you can do is you can then do more outreach and recruitment to try to get more women to apply. And the thinking is, over time, if you're hiring people fairly, that is going to reduce the underrepresentation. You also can look at, well, why are we so underrepresented as to women? Is this not a nice place for women to work? Do we need to look at having employee resource groups for women, with allies invited too, but for women? Do we need to look at maybe mentoring programs and things like that? Are those not available to women? Why do we have underrepresentation as to women? And you can take affirmative action to address that. But what you can't do, and I really need to reiterate this because probably for a time, at least before the Supreme Court decision, some companies may have done this, even though under the rubric of affirmative action, but you're really not supposed to, you can't give a preference. You can make sure that you're considering a diverse applicant pool, but when you make that final decision, it has to be based on merit.
And that's exactly what should happen. I will tell you though, having a number of employers that we work with, that's not what happens all the time. And that's very frustrating. There's people in my team that are sitting in this room right now and they're cringing because they're like, yes, about 50% of our conversations are about this. So it's a big reason why you, as a leader in a company, you need to know these rules because employers really don't know them. In your paper, it talks about the Algorithmic Accountability Act failed in 2019. And now it's running back up again. It's 2022, but they haven't passed it yet. Why is it failing? Do you have any background on this?
Because Congress can't do anything.
Okay. You heard it here.
It's pretty simple. And we could talk about how, that was a law that really was going to give the FTC more power, but whether or not there's new laws related to algorithm, from my perspective, that's not really the question. It's, in the executive branch, because I still believe in separation of powers. And it doesn't matter what Congress do. If they give us new laws to enforce, we'll enforce them. But we're left with longstanding civil rights laws that we have to apply equally to new technology as we would to employment decisions made by pencil and paper. So I think a lot of the, what's going on in Congress now, whether we need new laws, or we need an AI commission, or we need an Algorithmic Accountability Act, is an interesting question and certainly getting a lot of publicity, but it's also a huge distraction for federal enforcement agencies like ours that have a mandate right now to be enforcing laws. And there's nothing in the laws that says, employment discrimination doesn't apply to algorithms. Right. And with that chaos and confusion out there, with Congress now getting very aggressive in this, and state and local governments also trying to regulate in the AI area, it allows employers and companies and vendors, who don't, certain vendors who want to be more aggressive, to say, well, there is regulatory uncertainty now with artificial intelligence. So use these products, develop these products, fund these products, without necessarily the same liability that you may have down the road. And you can make a lot of decisions and make money in that meantime. And that really moves the goalpost in a sense where right now that's not true. For each use of AI, whether it's in employment, housing, finance, across the board, there are longstanding laws that apply, and there's various agencies that enforce those now. So I think because that's generally what Congress does and proposes bills and has hearings, it's really a distraction from current obligations.
Yeah, I totally agree. Also, absolutely. Just let me add one point. I don't think people that don't know anything about algorithms should be writing rules around them.
Well, I would say, though, that I think it would be useful to have a federal standard, algorithmic bias, at some point. Right now, what you're seeing is sort of starting to develop a hodgepodge of state and local laws in this area. Probably the leading law on algorithmic bias at the moment is the New York AI law. And the New York AI law, has been, really subject to scrutiny, and they've backed away from some parts of it. It had a fairly broad definition of AI. It's been narrowed somewhat. But ultimately, you're looking at whether there's a particular AI or algorithm, like let's say you're using it to try to pick who to hire, and it gives a score, for example. That algorithmic bias law in New York wants to make sure that they frankly want you to report, but ultimately what they're trying to get at is they want to make sure that if candidate A is a man and candidate B is a woman, and they have the same resume basically, but one's a man and one's a woman, that the male candidate won't be treated better or the female candidate treated better because of their gender. And then they also look at points that are not job related that are sometimes correlated with gender. And ultimately you're looking to see if people are treated differently based on gender or race, and you have to publish that based on your experience, looking at many, many different observations of how did male and female candidates, how did they do? Well, the issue is that some other states may take a different approach as to how they look at algorithmic bias. There's different ways you can look at it. The EOC, for example, and Keith mentioned this, they apply the uniform guidelines. So they're mostly looking at, in practice, how does an algorithm work in a given job group or a given job title in terms of who you select? Is it causing adverse impact based on race or gender? And if so, can you validate that AI procedure or technique? Now, is that sufficient? I don't know. I mean, that's what we have, as Keith mentioned. In the long run, you probably do want to look at the algorithm itself, because if you can satisfy the 4/5 rule, for example, or you can show that there's not a 2 standard deviation disparity in how men and women are being treated in a given job title, but you know that the AI is biased a little bit in favor of men, you still probably want to have a standard for that too, because so you want to have a standard. And most of the best AI companies want to have guidance there because they don't want to be subject to the Wild West. And what I mean by that is they don't want to have to go to court and have this decided case by courts. They would prefer a rule that they could comply with. I'm on an AI ethics council, for example, and that's, something that we look at. So for a company. So, that's something I'm very aware of. The idea of a federal standard, though, would be helpful. Now, we want it to be a good standard.
Right. That's the point.
That's the point you're making.
That's right.
And you want it to be, if I may say, I don't know if it's controversial or not, but you want it to be a pro-AI standard in the sense that artificial intelligence is coming.
No, it's here.
It's here. It's coming in a bigger and bigger way, and we want to be competitive as a country. There's a lot of benefits to artificial intelligence, and we don't want to lose out on that by being too conservative, and I don't mean a political sense, but too conservative as we approach AI. We want to be open to it because we want to be the leading country in this area, as we have been in the past in many areas.
Well said. I think too, in the sense that right now, because it is widely used, and the debate on whether to regulate technology is certainly very powerful right now. But I know that my agency is never going to be able to know how to regulate technology.
Right.
That's just not what we do. And also, a lot of employers using this technology are not going to ever understand the algorithms. They don't have time. And even if they could, it's all numbers and math that may change. And if you look at our federal investigators that have to show up to investigate employment discrimination, that's what they know how to do. And we can't lose sight of the fact at the end of the day that this AI, especially in employment and HR functions, and it's not just in hiring, firing, it's literally every function that human resources does, from the beginning, the decision to make a job description, to where to advertise, to who to hire, to how to do compensation, of where there's some algorithm out there that will make those decisions for employers, but using very complicated, sophisticated data sets, a lot of people just won't ever understand, like I just said. So what do we understand? What do we know? And that's an employment decision. And at the end of the day, if these tools are making an employment decision or they're assisting with an employment decision, there's going to be an employment decision, right? Just like in the other context, like a housing decision, a credit decision, whether it's made by a human or algorithm. So that's what we need to focus on, is the results, because that's how we know how to investigate. In a sense, backtracking the results from there is an argument that AI can make that process more transparent than how we've been trying to figure out employment decisions now. So if you think about it, one of our investigators shows up and somebody says they weren't hired because they're a female. So what do? We have to take a position of the hiring manager and we say, did you not hire Angela because she's a female? And how often do people ever admit that they have bias in a deposition? Oh, of course I didn't hire females. That's our policy at the company here. Not only will that company probably go out of business pretty quickly, it also violates a lot of federal law. So that's what we're dealing with now. If they say, of course not, I didn't hire, it had nothing to do with it when it really could. So what we're left with in understanding bias, and we're dealing now with the black box of hiring managers' brains. And, that's very tough to figure out in a sense. And, we've been doing that for 50 years this way. So now with technology coming into the equation, a way that, it can really help us in our job is that saying, okay, well, show us how you got to this decision. If it was using technology, there's obviously a lot of clicks. There's a lot of transparent ways that employers are trying to sift through resumes or advertise in certain places or make compensation decisions. And now employers have the ability to show through this technology of here's the factors that went in here. Here's the job, here's the local job market, here's the job description, here's the skills that make a candidate successful for this role. And this is what we inputted into the computer. And this is what the computer said who the top candidates were based upon those very neutral job-related categories that what's required to make an employment decision versus not having any of that. For employers who want to use these for the right purposes, for vendors who want to design these programs, with that in mind, it can really also help us make these cases easier, eliminate employment discrimination. If there's such a traceable, auditable record of the decisions that go into an employment decision, but right now, again, it's either somebody's brain or, let's see the squiggly notes during your employment interview to see if you wrote down woman or something, right? It's very hard right now to prove employment discrimination. So the more standards we want to put on regulating algorithms and saying, well, if we need a commission or we need this type of audit or transparency, at what standard now or that's going to impose when we don't have that currently related to humans making those decisions. So, and some of that might be necessary, as these tools get more advanced, but I think we need to look at it, in the framework of how can this really help us and help employers hire diverse candidates, hire candidates that actually have the skills and ability opposed to the long-standing issues. Look, there's bias in employment decision-making. Every year, we get between 70 to 100,000 cases. We always have 200 plus litigations going. And, the last 2 years, we've collected around $1 billion from employers from violating these laws. So, the problem is out there, whether or not it's algorithms or not. And there's just such a fear because of the potential that AI can scale that discrimination. And really, where it takes one person, there's and you probably know the stat better than I do, in talent acquisition, looking at a resume. The average talent acquisition person looks at that resume for 7 seconds. I don't know if that's still the right stat. So think about that. You got 6 seconds to, your whole life, your whole career, when you're applying for jobs, that's all you got, right? So if an individual has bias and saying, well, I don't want to hire somebody who's African-American or Asian American, look, they have to, or female, they have to look, is that a female name? Did they went to historically Black college? What indicators can I see that I want to eliminate that? So that's one bad actor, right? But that takes a lot of time. Still 6 seconds is a lot of time to inject bias. Now you have programs that can scale that within 0.6 seconds, you could look at 1 million resumes and inject that bias in there, quickly. And all those potential candidates who could do the job were eliminated based upon, that hiring manager's bias. So you could see how quickly this discrimination can scale on the other side of it. So for all of this, you have to look at, okay, what are the potential pros of how we can help eliminate discrimination, how we can use these softwares to actually have employers take a merit and skills-based approach and no other factors, which is not only what the law allows, which is what you would all want to entering the workforce, but on the other side, how do we prevent employers from using these tools to violate these laws in a fashion and way and a scale that we've never seen before?
The soft law compliance. So this was in your paper, and would you talk about this? Because I've never heard this. I'm not a lawyer.
So this basically is saying that everything related to some of these new proposals you heard in New York of having a yearly audit requirement, or in the EU, what they're trying to do, and they're trying to be like they did with GDPR instead of Brussels standards for the whole world with their EU AI Act. And they're going to categorize different AI uses based on risk. And if there's certain risk associated with the product, you're going to have to do pre-deployment audits, yearly testing. And they've said that employment would be in the highest risk category, which would require a lot of those additional governance structures around it. And, my perspective on all of this is that, having been a former defense lawyer for companies in employment, is that everything that's being proposed, everything that's out there, companies can be doing right now. And, using the existing framework. So if New York is going to say to use AI, you need to do a yearly pre-deployment audit. Companies do audits, internal audits all the time. in the employment space, whether it's pay equity audits, whether it's overtime audits, minimum wage audits, that is constantly occurring. And because a lot of these tools are actually being used to make employment decisions, there's nothing preventing the employers from going in and saying, we want to use this tool. Let's test to see if it has a disparate impact. If it is unlawfully excluding people of certain races or disabilities. And you can do that internally, which is where a lot of these laws are going right now, and fix that before it ever makes a decision on someone's livelihood. And that's what the difference is in AI in HR versus other areas like logistics or making widgets. You're dealing with some of the most fundamental civil rights we have in this country to enter and thrive in the workforce without being discriminated against. So all of this internal mechanisms, governance that can be built around these tools for whatever it is, using the existing law, which applies everywhere in the territories, can be happening right now. And companies are so familiar with doing that in other spaces outside of technology. In the banking industry, doing it all the time with their models and their risk assessments and credit inquiries before it actually makes those decisions. And the same thing just needs to be happening here. And the reason I'm saying that from my perspective too, is that I believe that that's just going to put the companies, again, it will prevent discrimination from ever occurring in the first place if you're doing it in more of a test situation before deploying the system. But even if you do find that there is discrimination, you can either fix it or you're just going to be in a better position. So if our investigators show up and you say like, look, this is the questions we asked the vendor. We worked with them. We asked about testing. We did our own testing. We only ensured that certain individuals who were trained by the vendor had access to these systems. We just built a whole governance around it, testing around it, because we know that it's making decisions about people's individual to enter the work, an individual to enter the workforce. Here's everything we did. And if some discrimination occurred, you may be able to justify that, or you're just in a better position than another company using a software who just bought and said, well, this vendor, which a lot of them do, promised me diversity, equity, inclusion. They promised me it's going to handle all my hiring needs if I just pay a lot of money and I don't have to do anything. And that's how AI is being sold. It's being sold, if you look at some of the other uses like Salesforce or other companies outside of employment, it's, buy this expensive software. It's going to make decisions faster. You're going to save money, right? And in HR just can't be sold that way, even though it is. And especially with companies now want to diversify, want to make sure that they have fair hiring. Companies are buying this and they're just saying, well, we just let it go because that's what the vendor said. And let's get to the broader point is that in this space, vendors have no liability. In employment law, the EEOC only has jurisdiction over the employer, the unions, or the staffing agencies, employment agencies. That's it. So whatever decision these tools make, whether the robot completely, wants to discriminate against somebody, it doesn't matter. The vendor has no liability. It's 100% the liability rests with the employer, which is why, another care needs to be taken because they can't come and say, well, we don't know. This vendor made the decision. We don't even have access to the data. It was completely them. Go after them. That's just not how it works. We go after the company using this, which is different than other uses of technology. So going to my point, the more you do that, the more you build those internal structures and test it, you're just going to be in a better position than the company that doesn't. And when we show up for an investigation, we have very limited resources, right? We have jurisdiction over, the vast majority of U.S. employers, and we have 2,000 investigators to deal with every claim of discrimination in the United States. So the more you can show there in good faith, the more then we could use our resources on bad actors who are intentionally using this software to discriminate for a competitive gain or not doing any of these governance programs. So that's sort of been my theory on all that. It just puts you in a much better position knowing that we have such limited resources for these investigations.
Right. Okay. So now we're going to do predictions. This is going to wrap everything up. I want to hear what you think is going to happen 2024 to 2026. So we kind of know how this year is going to end up. What are we going to be faced with the next 3 years?
Well, I think you're going to see by 2026 that AI is being used in all aspects of life, decision-making, the economy, all aspects of employment, that frankly would be malpractice of sorts not to use AI in selection in employment because the algorithms are going to get better. They're going to have to comply with these variety of laws that are coming out. So there's going to be less reason not to use AI and a lot of reasons to use it to identify the most skilled most meritorious individual. So I think that's going to become the standard of care within 3 or 4 years. Already over 90% of, I think I saw something that said 99% of the big companies are using it in some way in employment. That's one. And then two, and this is more from a governance perspective, federalism has a lot to say for it in certain areas. But I have to say in this area, if we really stick to federalism and how we apply this and the federal government doesn't come in with a standard, we're all going to have to comply with California and New York law, because what you see is you have the large companies
And
that
you're
are hiring remote workers, and some of them are, and if one of them's in California or two of them's in California, what you end up seeing is that most companies, now I advise companies, decide to just, we're just going to follow the most restrictive or the most protective law so that we don't have to have 50 different regimes within our own company. And so they end up following California and New York law. And that's what's happening with the New York AI law. It would be better if both states that want protective AI laws and ones that want probably more permissive ones to act through Congress the way it's supposed to be and create an algorithmic bias law that makes sense.
I just think, the short term of everything with generative AI and it's going on with ChatGPT, I do think that Congress or state and local governments will tackle that. And I think the low hanging fruit there is going to be around the copyright issues that we're seeing now about the musics and creating content and stealing content. So my prediction, just knowing, having been involved in this now for the last couple of years on the, you talk about the beginning of the machine learning side, the much more complicated side than
That's right.
the large language models that you've been doing for a long time too. Legislators understand ChatGPT because everyone's grandma can use it and they can see that it's producing something opposed to these very complex algorithms making business decisions. So in a way, I think with these bipartisan committees, you're likely going to get some guardrails legislation around privacy concerns related to that, ownership concerns, copyright concerns. So I think that's going to be the most immediate sort of, if there is a federal standard, it's going to go there. But these granular uses for the short time, I think you're going to see a lot of chaos with foreign governments and state and local governments making rules that may even conflict with what employers' obligations are at the federal level. And they're just not going to get a pass when it comes to that.
The one thing I've seen is now small companies, medium-sized companies are all adopting it too, because they feel like that the large companies have all the advantage because they adopted AI first and they're losing talent. They're not able to find talent in an unbiased way. So I think that there's a lot of benefit that has been shown from the technology. I do think that we're going to start seeing a divide between companies just saying, I'm not willing to go the extra mile. I'm just going to drop out of the space. It's hard to be an AI company. It takes a lot of money, it takes a lot of resources. But I do hope that industry and government can continue to work together. I love the fact that we're able to partner with both of you on something like this and bring some of these questions to the forefront. That is how we will be able to provide a competitive edge for our company or for our country. I agree with you, Craig. Like if we don't do that, if we don't keep our competitive edge, we're not doing what we're intended to do as companies and as legislation.